Emmanuel and Margarita, American citizens and employees of the U.S. State Department, got married in the African state of Kenya, where sterility is a ground for annulment of marriage. Thereafter, the spouses were assigned to the U.S. Embassy in Manila. On the first year of the spouse's tour of duty in the Philippines, Margarita filed an annulment case against Emmanuel before a Philippine court on the ground of her husband's sterility at the time of the celebration of the marriage. Will the suit prosper? No, the suit will not prosper. The nationality principle set forth in Article 15 of the Civil Code will govern the relations of Emmanuel and Margarita. Since they are American citizens, the governing law as to the ground for annulment is not Kenyan law, which Margarita invokes in support of sterility as such ground, but should be U.S. law, which is the national law of both Emmanuel and Margarita as recognized under Philippine law. Hence, the Philippine court will not give due course to the case based on Kenyan law. The nationality principle, as expressed in the application of national law of foreign nationals by Philippine courts, is established by precedents. Juan is a Filipino citizen residing in Tokyo, Japan. State what laws govern. A. His capacity to contract marriage in Japan. B. His successional rights as regards his deceased Filipino father's property in Texas, USA. C. The extrinsic validity of the last will and testament which Juan executed while sojourning in Switzerland. D. The intrinsic validity of said will. Juan's capacity to contract marriage is governed by Philippine law, the Family Code, pursuant to Article 15, Civil Code, which provides that our laws relating to, among others, legal capacity of persons are binding upon citizens of the Philippines even though living abroad. B. By way of exception to the general rule of lex residi prescribed by the first paragraph of Article 16, Civil Code, a person's successional rights are governed by the national law of the decedent, second paragraph, Article 16. Since Juan's deceased father was a Filipino citizen, Philippine law governs Juan's successional rights. C. The extrinsic validity of Juan's will is governed by A. Swiss law, it being the law where the will was made, Article 17, first paragraph, Civil Code, or B. Philippine law, by implication from the provisions of Article 816, Civil Code, which allows even an alien who is abroad to make a will in conformity with our Civil Code. D. The intrinsic validity of his will is governed by Philippine law, it being his national law. Jean and Jane, Filipinos, met and got married in England while both were taking up postgraduate courses there. A few years after their graduation, they decided to annul their marriage. Jane filed an action to annul her marriage to Jean in England on the ground of the latter's sterility, a ground for annulment of marriage in England. The English court decreed the marriage annulled. Returning to the Philippines, Jean asked you whether or not he would now be free to marry his former girlfriend. What would your legal advice be? No, Jean is not free to marry his former girlfriend. His marriage to Jane, if valid according to the forms and solemnities of British law, is valid here, Article 17, first paragraph of the new Civil Code. However, since Jean and Jane are still Filipinos, although living in England, the dissolution of their marriage is still governed by Philippine law, Article 15 of the new Civil Code. Since sterility is not one of the grounds for the annulment of a marriage under Article 45 of the Family Code, the annulment of Jean's marriage to Jane on that ground is not valid in the Philippines, Article 17, paragraph of the new Civil Code. In 1985, Sunny and Lulu, both Filipino citizens, were married in the Philippines. In 1987, they separated, and Sunny went to Canada, where he obtained a divorce in the same year. He then married another Filipina, Oring, in Canada on January 1, 1988. They had two sons, James and John. In 1990, after failing to hear from Sunny, Lulu married Terso, by whom she had a daughter, Verna. In 1991, Sonny visited the Philippines where he succumbed to heart attack. Discuss the effect of the divorce obtained by Sonny in Canada. The divorce obtained by Sonny in Canada shall not be effective as he is still a Filipino citizen at the time he acquired the same. Paragraph 2, Article 26 of the Family Code contemplates a situation where the spouse who obtained the divorce decree already ceased to be a Filipino citizen. The reckoning point of the mentioned provision is the citizenship of the spouse at the time he obtains a divorce decree. If the spouse is still a Filipino citizen, as with the instant case, Article 15 of the new Civil Code will apply. Hence, the divorce decree obtained by Sonny shall not be recognized in the Philippines. Brad and Angelina had a secret marriage before a pastor whose office is located in Aracero Street, City of Manila. They paid money to the pastor who took care of all the documentation. When Angelina wanted to go to the U.S., she found out that there was no marriage license issued to them before their marriage. Since their marriage was solemnized in 1995 after the effectivity of the Family Code, Angelina filed a petition for judicial declaration of nullity on the strength of a certification by the Civil Registrar of Manila that, after a diligent and exhaustive search, the alleged marriage license indicated in the marriage certificate does not appear in the records and cannot be found. Decide the case and explain. I will grant the petition for judicial declaration of nullity of Brad and Angelina's marriage on the ground that there is a lack of marriage license. Article 3 of the Family Code provides that one of the formal requisites of marriage is a valid marriage license, and Article 4 of the same code states that absence of any of the essential or formal requisites shall render the marriage void ab initio. In Abbas v. Abbas, 689, SCRA 646, 2013, the Supreme Court declared the marriage as void ab initio because there is proof of lack of record of marriage license. The certification by the Civil Registrar of Manila that, after diligent and exhaustive search, the alleged marriage license indicated in the marriage certificate does not appear in the records and cannot be found proves that the marriage of Brad and Angelina was solemnized without the requisite marriage license and is therefore void ab initio. The absence of the marriage license was certified to by the local civil registrar who is the official custodian of these documents and who is in the best position to certify as to the existence of these records. Also, there is a presumption of regularity in the performance of official duty, Republic v. CA and Castro, 236 SCRA 257, 1994.